Good morning, friends. Be settled. I am going to discuss important topic relating to advocate on record examination of Supreme Court of India. Friends, I am talking about case law of MBA, Madras Bar Association versus Union of India, that is of 2020. It is a significant ruling by the Honorable Supreme Court of India that dealt with the issue of appointments to the National Company Law Tribunal as well as to the National Company Law Appellate Tribunal, and the constitutionality of certain provisions of the Finance Act 2017. Friends, before going to the judgment part, I am going through facts of the case. So let us firstly dive into the facts of the case. We all know Madras Bar Association, shortly MBA, is an association of lawyers practicing in the Madras High Court. It challenged certain provisions of the Finance Act 2017 before the Honorable Supreme Court. Primarily concern was appointment of members to the National Company Law Tribunal and National Company Law Appellate Tribunal. Petitioners raised concerns regarding the independence and neutrality of the members appointed to these tribunals. Specifically, they argued that the appointments as governed by the Finance Act 2017 were in violation of separation of power doctrine and the basic structure of the Constitution, which guarantees judicial independence. The issue also reiterated that it relates to the fact that appointments process for the NCLT and NCLAT were centralized, with the union government having a significant control over the appointments, potentially undermining the independence of these tribunals. So, friends, key issues that were raised in this judgment case were firstly relating to the constitutionality of the provisions of the Finance Act 2017. So the primary issue was whether the provisions in the Finance Act that govern the appointment of judicial members to the NCLT and NCLAT were constitutional. This was the issue. Constitutionality was the issue. The petitioners specifically challenged Section 184 of the Finance Act 2017, which dealt with the appointment and terms of service of members of the tribunal. Second issue was independence of the judiciary. Whether the process of appointing members to the NCLT and NCLAT violated the principles of judicial independence as granted by the Indian Constitution. Third issue was separation of power. whether the centralization of the appointment power in the hands of executive, that is union government, was violation of the separation of power doctrine, which is considered as part of basic structure of the Constitution. Fourth issue related to the role of selection committee. The petitioners questioned whether the selection process for judicial appointment to the tribunal was transparent and whether it involved adequate consultation with the judicial authorities. So these were the main issues on which our Honorable Court gave its ruling. Firstly, I will say that in its ruling in 2020, the Supreme Court delivered its judgment in favor of the Madras Bar Association and struck down certain provisions of the Finance Act 2017 as being unconstitutional. So let us now explore the key points of the judgment. First point is infringement on judicial independence. This was held. Honorable Supreme Court held that the provisions relating to the appointment of members to NCLT and NCLAT were inconsistent with the principles of judicial independence. It found that the process as framed by the Finance Act 2017 did not provide adequate safeguards for judicial independence and violated the basic structure of the Constitution. Honorable Court further held that judicial appointments must be done in a manner that ensures the independence of the judiciary and that the executive cannot have an overriding influence on the appointment to quasi-judicial bodies like NCLT and NCLAT. Secondly, the ruling gave its judgment on selection process and transparency. This court, mean to say Honorable Supreme Court, noted that selection process for judicial members of the NCLT and NCLAT needed to be transparent and should involve judicial oversight. This court emphasized the need for a process that upholds principle of independence and ensures that appointments are made with a proper judicial influence and not purely executive driven. Thirdly, it also gave its ruling on constitutional safeguards. Honorable Supreme Court emphasized that appointment to the tribunal like NCLT and NCLAT must follow the principles of constitutional propriety and maintain the separation of powers. The court struck down provisions that gave the executive undue influence over the appointment of members, suggesting that there should be a more independent and transparent process for such appointments. Fourthly, it ruled lack of judicial oversight. Honorable Supreme Court specifically criticized the lack of judicial participation in the process of appointment to the NCLT and NCLAT, ruling that the transparent mechanism that involves judicial representation is necessary to hold the independence of the tribunal. Fifth was impact on the structure of NCLT and NCLAT. This judgment also affected the structure and functioning of the NCLT and NCLAT. And the court observed that these bodies, being quasi-judicial in nature, should not be under the direct control of the executive, but should rather be formed through a more balanced and judicially influenced process. So, friends, after giving such a detailed ruling on various points, there is sure to be a significance of the judgment or future effect also. This ruling strengthened judicial independence. So the judgment strengthened the doctrine of judicial independence in the context of quasi-judicial tribunals. It ensured that executive's control over judicial appointment would be subject to constitutional constraints, maintaining the separation of power between the executive and judiciary. It also made the cause for review of Finance Act 2017. This ruling led to review of the appointment procedures for the tribunals like NCLT and NCLAT, and marked a significant move towards ensuring greater transparency and independence in the functioning of these bodies. Balance of powers. The decision underlined the importance of maintaining the balance of power between the executive, legislature, and judiciary. The court held that tribunals, though not strictly judicial bodies, should have independent processes to the appointment of members to maintain their credibility and impartiality. There was also impact of the judgment on other tribunals' selection process. This ruling gave wider implications for other tribunals in India, suggesting that appointment process for tribunal members should be revisited to ensure judicial independence and avoid executive dominance. This ruling served as a guidance for future appointments. This ruling provided guidance for the future constitution of tribunals, recommending that appointment should be made by a selection committee involving judicial authorities rather than executive alone. This could serve as a precedent for how appointment to other quasi-judicial bodies are structured in the future. So, friend, this video has become quite long. You may not be physically healthy. Some of might be old person may go up to end of this video. So I am concluding my video with the conclusion that this case, Madras Bar Association versus Union of India 2020, is a landmark decision that dealt with the independence of the judiciary and appointment process for judicial members of National Company Law Tribunal and National Company Law Appellate Tribunal. Honorable Supreme Court struck down certain provisions of the Finance Act 2017, which were seen to give executive undue control over the appointment of the tribunal. And it emphasized the need for judicial participation in the selection process. This decision is a significant in ensuring judicial independence of tribunal and preserving the separation of power within India's constitutional framework. So, friends, those who are aspirants for advocate on record examination must share this video with your other like-minded friends who are also appealing so that they may get benefit from this little hard work of 1.5 hours. As I had gone through the judgment, then prepared brief, then I am putting in the video form before you. So don't fail to like my video and subscribe and share with other like-minded peoples. God bless you all. See you again. Have a nice day.